Utah has a landlord-friendly late fee framework with minimal state-level regulation, giving landlords broad discretion while still requiring that fees be reasonable under general contract principles. The governing law is found in the Utah Fit Premises Act, Utah Code Title 57, Chapter 22, along with general landlord-tenant provisions and contract law. If you're a landlord or tenant in Utah, the state provides a straightforward environment where the lease governs most late fee details. Let's start with the basics. Utah does not impose a specific statutory cap on late fees. There is no percentage limit, no dollar maximum, and no statutory formula dictating how much a landlord can charge. The late fee amount is governed by the lease terms and general contract principles. Specifically, the requirement that the fee represent a reasonable pre-estimate of the landlord's damages from the late payment, rather than an unenforceable penalty. Utah also does not mandate a grace period by statute. There is no state law requiring a specific number of days before a late fee can be charged. If your lease says rent is due on the 1st and a late fee applies on the 2nd, that's enforceable under Utah law. However, most Utah landlords include a grace period of 3 to 5 days as standard practice. It's considered good business and reduces disputes. The key legal principle in Utah is the distinction between a reasonable liquidated damages provision and an unenforceable penalty. Under Utah contract law, a liquidated damages clause, which is what a late fee provision essentially is, must satisfy two conditions. First, the damages from late payment must be difficult to calculate precisely at the time the lease is signed. Second, the fee must be a reasonable estimate of the anticipated damages, not grossly disproportionate to the landlord's actual costs. Late payment damages are generally considered difficult to calculate precisely, which satisfies the first condition. The question is whether the fee amount is reasonable. Utah courts evaluate this based on the landlord's actual costs: administrative time, additional accounting, follow-up communication, bank fees, and the time value of money. A fee that roughly corresponds to these costs is enforceable. A fee that dramatically exceeds them is vulnerable to challenge. What's reasonable in Utah? Given the state's rental market, which ranges from very affordable in rural areas to expensive along the Wasatch Front, the answer varies by market. Industry standards suggest that a flat fee of $50 to $75 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible. In the Salt Lake City metro, where rents commonly range from $1,400 to $2,000, a fee of $75 to $150 falls within the reasonable range. In more affordable markets, Provo student housing, rural Utah, lower dollar amounts are appropriate. Utah's relatively fast eviction process affects the late fee dynamic. Under Utah Code Section 78B-6-802, the landlord can file for eviction with just 3 days' notice for non-payment of rent. This fast timeline means that chronic late payment escalates to eviction quickly, and the late fee provisions interact with the eviction timeline almost immediately. Whether unpaid late fees can be included in the 3-day notice depends on how the lease defines them. If late fees are defined as additional rent, they can be included in the total amount demanded. Compounding late fees in Utah are governed by the lease terms and the reasonableness standard. If your lease charges a one-time fee after the grace period, that's straightforward. If your lease imposes daily or weekly charges for continued non-payment, the total accumulation must still be reasonable. A compounding structure that could produce fees exceeding 20 or 30% of the monthly rent within a few weeks would likely be deemed an unenforceable penalty, even in landlord-friendly Utah. Most Utah landlords use one of two approaches: a single flat fee after the grace period, or a flat fee plus a smaller daily charge that's capped at a maximum. For example, a $50 fee on day 6 plus $5 per day, capped at an additional $50. The cap prevents the fee from spiraling into unreasonable territory while still creating an incentive for the tenant to pay promptly. The lease must clearly state the late fee terms for them to be enforceable. The lease should specify the rent due date, any grace period, the exact fee amount or formula, when the fee triggers, whether additional charges apply for continued non-payment, and any cap on those charges, and whether the fee is defined as additional rent. Ambiguity works against the landlord. A court will resolve unclear late fee provisions in the tenant's favor. Utah has a specific provision regarding non-refundable fees that's relevant to the late fee context. Under Section 57-17-3, any non-refundable fee must be clearly identified as non-refundable in writing before being collected. While this provision primarily applies to move-in fees and deposits, the principle of clear written disclosure extends to all fee structures, including late fees. Document everything in writing. For tenants receiving Housing Choice Voucher Assistance, Utah landlords should not charge late fees when the Housing Authority's portion is delayed due to processing. The tenant cannot control the Housing Authority's payment timeline. If the tenant's portion is paid on time, the late fee should apply only if the tenant's own payment is late, not because the total rent amount hasn't been fully received due to the authority's processing schedule. Utah's significant military population, centered around Hill Air Force Base near Ogden, Dugway Proving Ground, and Tooele Army Depot, means that SCRA-related late payment situations arise occasionally. Military pay is predictable, the 1st and 15th of each month, and most military tenants pay reliably. When late payments occur from military tenants, they're often related to PCS transitions or deployment disruptions that resolve quickly. Utah's standard grace period of 3 to 5 days typically accommodates these short delays. Utah's strong population growth, particularly along the Wasatch Front, has tightened the rental market significantly. In a tight market, landlords have strong applicant pools and can screen for payment reliability. Thorough screening reduces the need for aggressive late fee enforcement because well-screened tenants pay on time. The Tech Corridor, Silicon Slopes, running from Lehigh through Draper, has particularly strong demand from well-compensated tech workers who rarely pay late. Late fee enforcement in this market segment is minimal. More affordable markets, West Valley City, Ogden, parts of Provo, have more diverse tenant populations where late payment is more common and fee enforcement matters more. Provo-Orem has a unique dynamic driven by Brigham Young University and Utah Valley University. Student tenants whose financial aid is delayed may pay late at the beginning of each semester. Some landlords near BYU build this pattern into their expectations and communicate proactively with student tenants about grace periods and fee policies. BYU's honor code culture generally produces responsible tenants, but the financial aid timing issue is real. From a practical standpoint, Utah's landlord-friendly environment means your late fee provision will generally be enforced as written, as long as it's reasonable. This is an advantage, but it also means the lease must be well drafted because there's no detailed statutory framework to fill in the gaps. One best practice for Utah landlords: set your late fee at a level that creates a meaningful incentive for on-time payment while remaining defensible as reasonable. In the Salt Lake Metro, a fee in the range of 5 to 8% of the monthly rent hits this sweet spot. In more affordable markets, calibrate the dollar amount to the local rent level. A fee that's reasonable on a $2,000 rent may be excessive on an $800 rent. Another best practice: include a grace period of at least 3 to 5 days, even though Utah doesn't mandate one. A grace period demonstrates good faith, accommodates minor delays like weekend mail processing, and makes the fee more defensible if challenged. Most Utah landlords use 5 days as the standard. A third best practice: define your late fee as additional rent in the lease. This allows you to include unpaid late fees in the total amount on any 3-day pay or quit notice, simplifying the eviction process if the tenant falls into chronic non-payment. Without this definition, you may need to pursue the late fees as a separate claim. Utah requires landlords to return the security deposit within 30 days of the tenant vacating. Unpaid late fees can be deducted from the deposit if the lease authorizes the deduction and the fees are reasonable. The deduction must be itemized in the written statement provided to the tenant. For the complete guide to Utah late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.